in which people leave coins for good luck. And basically just this kind of abundance of reverence for trees in Ireland and other early cultures just shows this widespread appreciation for trees, obviously for their practical functions, but also their more than human qualities and this strong association with a sense of place and cultural identity. Now, Brehon law is, of course, a product of its time, but it's remained in place for a significant period of time, which shows us its effectiveness as a legal system, but also kind of the respect and the high regard the people of the time had for these laws and the values that they seem to embody. It was foreign invasions and colonization that led to the ultimate demise of this Brehon law system. And obviously our laws and our relationship with the natural world have changed drastically since early Irish times. And of course, we can't transplant an ancient legal framework into modern day Ireland, and I definitely don't think we should try. But I do think it is worth reflecting on whether insights from our Brehon law heritage and the values that seemed to be exhibited at the time, could we apply those to present day Ireland? So on that note, I'm going to pass you back to Julian, who's going to take you through part 2 of this lecture.
Thank you so much, Niamh. I will then share my screen, if you will bear with me for a moment. Now, is everyone able to see the screen?
Yep.
We're all looking at the presentation, okay.
It's just disappeared again there.
Oh, sorry. Yeah.
Yeah.
Okay. Thank you so much, Niamh, for that wonderful presentation on the insights of Brehon law. Now, for part 2, I will present to you the overview of the notional biocultural rights in literature, in international law, and in case law in national jurisdictions. In this part of the lecture, we'll talk about the definition and elements of biocultural rights. We'll talk about a little bit about the background. We'll set out two main elements of the rights. That is promotion and conservation of cultural diversity, and then governance, autonomy, and interest in environmental protection. And then we'll discuss some of the legal effects of recognizing biocultural rights, and then we'll address a critique of the notion of biocultural rights in scholarship. So what is the background of biocultural rights? Biocultural rights emerge as a community-led alternative to the Western development model, grounded on 4 movements: the post-development or people-centered ecology, the movement for the commons, an ethic of stewardship, and third-generation human rights. So the post-development movement seeks to give new value to ecological practices as a result to a critique of techno-bureaucratic development and nature conservation models. The movement for the commons is actually the result of some evidence that has shown that in certain circumstances, communities have best ensured ecosystem conservation, and that in other circumstances, there have been counterproductive effects of state control or privatization of the commons. An ethic of stewardship would resignify self-determination for Indigenous peoples and local communities to preserve their status as original trustees of the earth. And then third-generation human rights would be, for example, the rights to a healthy environment, social and economic development, and cultural heritage as motors of impulsion of biocultural rights. So what would be a definition of biocultural rights? Biocultural rights can be defined as the basket of collective rights that indigenous peoples and local communities need to maintain their role as stewards of the environment. Under this definition, biocultural rights would require legal recognition, are environmentally conditioned rights, and more on that later on during the presentation. They imply a form of self-determination as a group of people sharing spatial, social, cultural, and economic elements, and they signify a special collective relationship of the local community with the environment and its natural resources, which is the key element of the definition of biocultural rights. So as I said, there are two defining aspects or elements of this biocultural rights definition proposed by scholarship. The first one would be the self-identification of local communities as a new or traditional group of people sharing spatial, social, cultural, and economic elements. The second one would be the collective relationship of local communities with the local environment and its natural resources. So consequently, four entitlements stem from these two aspects of biocultural rights. The first one would be the right to self-determination, most particularly self-governance. So local communities have rights to self-government, which entails a degree of political autonomy of traditional institutions of local communities to regulate internal matters under their own rules, customs, and practices. The second one would relate to rights to access to land, water, and natural resources, including protection from external threats to the environment. A third entitlement links biocultural rights with the protection of cultural identity. Local communities must be guaranteed the broader right to maintain cultural, social, and religious specificities without experimenting discrimination by the state or by the rest of society. And lastly, biocultural rights require other associated environmental, substantial, and procedural rights to assure their legal effectiveness. For instance, access to environmental justice, the right to prior and informed consent regarding exploitative projects, and what scholars have called the rights to the application of precautionary approach. So biocultural rights of local communities are said to be in a somewhat difficult position to be defined because local communities are a nebulous concept. They have a very heterogeneous composition. However, for practical purposes, they have been defined as groups of people whose livelihoods are determined by their ecosystem. So this will bring us back to the elements and to restate that biocultural rights are thus community-led solutions to environmental conservation, indicating a holistic relationship between nature and culture. Through a long-standing organization, strongly binding local communities to land and natural resources, local communities are presumed to have a stewardship role of those elements, which by itself deserves protection. So we come to the element of biocultural rights being environmentally conditioned rights. This has been suggested by Bavicata and Julia Sayeva in the writings about biocultural rights. They say that biocultural rights come with a caveat. The double foundation of biocultural rights implied that both nature and community culture must be protected, guaranteeing an ethic of environmental stewardship. So if local communities abandon their sustainably friendly ways of life and fail to comply with this duty, that may result in loss of rights, according to these scholars. However, in our view, this environmental conditioned character of biocultural rights is somewhat artificial. As the Colombian Constitutional Court had recognized in probably the only case so far of biocultural rights in the world, this, to my knowledge, the symbiotic relationship of nature and culture in a traditional livelihood has already an intrinsic value on itself because it is consistent with human dignity. So there is no need to maintain such requirements to enjoy protection. Also, the protection of such relationship already signals a preference for the low-level environmental deterioration caused by the traditional livelihoods over other extrinsic exploitative legal and illegal activities. The other critique that can be made is that if a local community were to change its sustainable lifestyle due to external pressures on their livelihoods and them being sustainable, they can always claim a breach of biocultural rights before the courts wherever these rights are recognized. And finally, biocultural rights do not exclude other right-based approaches, as we'll see in the Colombian examples. They can be paired or coupled with environmental rights, with rights of nature, or even with green constitutional rights if their enforcement fails. So what would be the legal foundations of biocultural rights? They are set out in international law. So there are binding and non-binding instruments in international law that have recognized or have set out principles for recognizing biocultural rights. In our view, the most important one would be Article 8J of the UN Convention on Biological Diversity. So this article has acknowledged, this provision has acknowledged that member states have the duty to respect, preserve, and maintain the knowledge, innovations, and practices of indigenous and local communities embodying traditional lifestyles relevant for the conservation and sustainable use of biological diversity. So that is where the environmentally conditioned nature of biocultural rights stems from. But in fairness, no reasonable reading of Article 8J of the CBD warrants such environmental condition rights. The key term in the provision would be traditional lifestyles, relevant for the conservation and sustainable use of biological diversity. However, under a pro persona interpretation, this provision could be read in a way traditional lifestyles are understood as determined by the ecosystem and thus as an essential part of the conservation and sustainable use of biological diversity, therefore relevant to it. Otherwise, the provision would not be consistent with human dignity, as this narrower interpretation would lead to arbitrary or restrictive limitations of biocultural rights. Other important international law legal foundations of biocultural rights are to be found in the recently approved Kunming-Montreal Global Biodiversity Framework, Targets 1 and 3, on the CBD Nagoya Protocol for sharing the benefits arising from the utilization of genetic resources in a fair and equitable way, in the Convention for the Safeguarding of Intangible Cultural Heritage, which is very interesting because it also protects all those cultural practices that are a community's response to their environment and their interaction with nature, as long as they are compatible with existing international human rights, and then with requirements of mutual respect among communities and of sustainable development. Then you would have some principles, on the Rio Declaration, on the Agenda 21, but in our view, the most important instruments, non-binding instruments, talking about biocultural rights pertinent for the purposes of this lecture, would be the Florence Declaration on the links between biological and cultural diversity. So this declaration has agreed, in this declaration, the participants have agreed that rural or urban livelihoods and well-being are closely linked to the status and trends in biological and cultural diversity, that the current state of biocultural diversity in Europe stems from the combination of historical and ongoing environmental and land use processes and cultural heritage, and that the European landscape is predominantly a biocultural multifunctional landscape, assimilating different processes in time and space. So this would mean that biocultural rights are meant to be understood in an expansive fashion, where they can even be used to protect that special bond between new or traditional livelihoods and ways of life that are dependent on nature. So continuing with the legal foundations of biocultural rights, I had advanced already the Colombian case, which is very particular to my knowledge, and I hope to be corrected and see that biocultural rights are already expanding more in other jurisdictions. It's the only country to have incorporated biocultural rights so far into its legal system through case law. So in this particular context, biocultural rights have been linked either with rights of nature or with compensation orders within transitional justice. There are two important cases, the Atrato River case decided by the Constitutional Court and the Magdalena River case at the Bogota District Court amidst what is called the Justice and Peace Law. So probably these two cases would warrant entire presentations on themselves, and they're very interesting. We could be here for hours discussing them, but what I would like you to retain is that there is, first of all, it is possible for national jurisdictions to incorporate biocultural rights. It is also possible to incorporate these rights without that environmentally conditioned character stipulated by scholars, and just by recognizing that special relationship between a livelihood that's dependent on the ecosystem deserves a protection in itself, because it has an intrinsic value based on human dignity, as any other human right. What is most interesting from the Atrato River case is the link between biocultural rights and rights of nature. For example, here, the court thought that the river, the Atrato River, was a right-holding entity, but as a right-holding entity, it required its prerogatives to be exercised through the stewardship of the local communities that inhabit nature or that have a special relationship with it. So in this case, the effectiveness of rights of nature, at least in theory, at least in the arguments of the courts, would be ensured by the exercise of biocultural rights, which is very thought-provoking. In the second case, which is the Magdalena River case, this is one of the most, I think, ambitious applications of biocultural rights and rights of nature I have come across to the moment. In this case, the Magdalena River was considered a natural living entity, not only for its cultural value, but for the cultural representations that form the river, that are individual subjects in themselves, which make these representations and the river itself as a subject of protection. So what happened in this case was that the river was used to hide all the atrocities of the war. Bodies were being were being disposed of into the river. And a lot of torture and terrible crimes against humanity were done by the paramilitary to the communities, and these meant that several practices, including fishing, including artisanship, including mobilization of the communities, festivals, gatherings, were interrupted and were seriously disturbed during the years of violence. So what the court is trying to do here is to declare nature as a victim of the armed conflict, and also mentioning that both the environmental degradation suffered by the river and the breaking of the link between local communities and nature should be restored to be compensated to restore the river's beauty, life, and secret harmony. So what would be the possible legal effects of recognizing biocultural rights? This would be mainly duties for states. So the recognition of lands and resource rights, the respect of autonomous decision-making processes, practices, and worldviews of local communities, the obtention of prior and informed consent of local communities, public participation enhancement in conservation strategies of local ecosystems. For example, in the Colombian case, there was a guardianship board set up with all the implementation problems that this entails in a developing country. But it was a thing that the court thought would be adequate to do. There would also be the environmental legislation enforcement and provision of remedies for environmental harm, and ensuring recognition, promotion, conservation, and expansion of new and traditional livelihoods, uses and practices depending on biocultural rights. And then we would have to see if you believe if you believe in the environmentally conditioned nature of biocultural rights, if duties would arise for local communities. What would be some strengths and shortcomings of biocultural rights? So some strengths would be that they would make for an effective vindication of both biocultural heritage and new uses, practices, and livelihoods of urban and rural communities alike that are dependent on ecosystems. They will also mean that could be more easily recognized because they already have a basis on international environmental law. However, there can be some legal hurdles to the recognition of these rights in national legal context. For example, if you have a country that have a state that has a dualist nature, such as Ireland, for example, to recognize or to make this sort of quantum leap into biocultural rights, you would need to pass a law at Parliament to do so. And that entails a series of considerations of political appetite and enough, concern for, both the protection of environment and culture to do that. So that would, be an obstacle that would hinder the recognition of biocultural rights. Also, biocultural rights, as any other rights, must be upheld before the courts when they're breached, to be protected. There will also be a risk of conflict or overlap of biocultural rights with other constitutional collective rights. And then there's also, the fact that there might be institutional apathy to integrate biocultural rights into policy and into decision-making processes. So that would be the end of part 2. We would love to receive any questions that you guys might have on the chat box. And we have some questions here to keep in mind for part 3 of this lecture. You can also look at those questions in the Padlet link that we have. And we hope to see you very shortly in about 10 minutes.
Maybe 5 minutes. Try to keep the momentum going.
Okay, Chief. 5 minutes it is.
But yeah, we'll be here in the meantime. But we'll give you a break. We'll be back in 5 minutes. But if anyone has questions or comments or anything like that, I think you actually had a comment in the chat during your presentation.
Exactly.
So just to clarify, did you want questions now, or did you want everyone to go and have a break now?
If anyone they can give them to us, or they could take a break as well. We'll have we have part 3 for this lecture, and then we'll have time for any questions as well at the end, if anyone has any.
Okay.
Yes, please.
Very simple. Could you give us back the last sheet?
I can in the presentation.
Yeah, because you had questions there. I would like to think.
Oh yeah, definitely. Thank you, Niamh.
No bother.
Thanks. Great.
I was wondering, and I'm sure you'll get into it more in part 3, or maybe not, but is there widespread practice of, respect for trees in the way that there used to be in Ireland to warrant biocultural rights, or is that not even necessary to have them in law? Coming from someone who's not a lawyer, so.
Yeah, I suppose I know Julian can chime in on kind of that basis of biocultural rights. Like, I wouldn't say that there is kind of overwhelming reverence for trees still existing. Like I was talking about, you can still see those tree rituals, and you can still see it in kind of cultural aspects across Ireland. But kind of compared to, I suppose, those environmental values that we saw in the past, that generally it seems that we are kind of disconnected from the local land and environment. But then that said, there are plenty of communities who are kind of rebuilding that relationship through whether it be kind of sustainable agriculture management or kind of local movements of rights of nature or whatever else. Julian, do you want to jump in there?
Yeah, what I would definitely say is that the aim of advancing biocultural rights, and then probably reimagining these relationships of people with trees, like probably they won't survive at the moment. They didn't survive at the moment, but there's a lot of other different relationships that people have with elements of nature, with nature in general, with particular ecosystems that could and should be redefined, and that can allow people to mobilize more as a community and use this platform more in a more let's say organizational manner, and then see what can they build up from there, and what can they vindicate legally. There's several examples on literature, and there's a whole array of publications regarding biocultural community stewardships, which we'll try to map out later on the presentation in part 3. But that would be the objective. Let's say that that what we wanted to portray with this lecture was the fact that people have these tools available, that there's documented evidence, there's documented experiences of other communities coming together and doing this, and that you don't have to necessarily be a local community or an ethnic or an indigenous people community with traditional and ancestral relationships with your land and resources to claim back some of these contributions of nature to your well-being and to your personal human dignity, to claim them and to use this platform of biocultural rights to do so. And that this platform is already set out in international law. In that sense, like I would say it would be a little bit more of a sure bet than rights of nature, which is a thing scholars and courts alike are struggling with, because there's a little bit of a lack of definition within the concepts of legal personality and rights holder status, and are they really rights, or they just environmental duties drafted in the language of rights, and so on. So that would be basically the goal of it.
Thank you.
Can I ask, maybe we should read around, Niamh or Julian, do you want to read the comments in the chat aloud, or do you?
Julian, could you do that? Because I'm
definitely. So Kira mentions that in Aotearoa, sorry, my Maori is terrible, in New Zealand, the Wanganui River may be another example. Yes, it is definitely an example. It is actually a strand of rights of nature on its own right, which is called the local participative governance strand of rights of nature. If you read, Minea, Tanasescu, and all of these scholars that talk about rights of nature strands. I would agree that it's also a way of seeing, biocultural rights, in the sense that the legal personality of the river is actually giving new value to the consideration of the Maori of the Wanganui River or even the Turawera Forest as a spiritual entity, and the way that it has to be translated into Western thought. So Kathleen says biocultural rights may also be a solid basis to help decolonize some aspects of both international and national environmental or human rights. I totally agree. I would even go further, like the colonization. I would actually, say that they make a great contribution in introducing social and environmental justice notions and principles to national jurisdictions, at least.
I think, unless there's any pressing questions, we could crack on to part 3.
Could I ask
No
a question?
No break.
Kind of following up from Kathleen's great point, and I'm hoping Kathleen will maybe turn on her camera and say some things at some point as well. But this point about it being able to help decolonize some aspects of our law. I mean, one of the things with our existing body of rights is they come with so much colonial baggage, right? Especially concepts like property, or even culture, and so although they've been used incredibly sort of powerfully and effectively by Indigenous peoples, that sort of burden of the history and language is very much there. But I'm wondering about the capacity of the idea of biocultural rights to sort of overcome that, but also, I guess, the worry about locking peoples into kind of ideas of stewardship or into particular sort of concepts of relationships to land that might not be temporally fluid, that might not be kind of always reflective or responsive or of either an historical or a future relationship to place.
Yeah, I would definitely agree. I like when we were preparing the class, we realized that, for example, I don't agree with that. I mean, I would contend that proposition of environmentally conditioning, biocultural rights, is incorrect. Like from the legal point of view, as I just explained, regarding an expansive interpretation of human rights, but also because you tend to incur in the risk that you just mentioned, but also the whole problem is let's say not only pertaining to experiences of other indigenous peoples and ethnic, local, or mobile communities with rights. It's the problem of claims rights in themselves. You need to go to court, definitely, to uphold them. That's where changes happen. Like no public authority is gonna do explicit and generous recognitions of rights in any part of the world, and this generates a conflict because it generates a problem. Because you have to translate all of this vindications that come nowadays with environmental degradation, that is called rightfully so by many, Kotze and many others, as a social environmental crisis. You have to translate those and argue a case and make a case and have a judge decide or a panel of judges decide, and then how effective is that decision? Is it possible to implement it? How is the government monitoring and enforcing these kinds of decisions? It's a very complex subject when it comes to rights, but I think there's something powerful, legally and politically and socially, in the language of rights, and that can be translated more into collective action than rather just, you know, play all your cards on the judicial scenario. Sorry, on the judicial, kind of like scenario, and you know, be awarded a negative outcome. Yeah, that would be my take on what you said.
I had a thought, kind of following from Dina's wonderful question, thinking about you know, the potential for biocultural rights to potentially be a bit limiting or constricting almost. But I believe Julian was talking earlier about the potential for them to be understood quite expansively, and I'm wondering if the role of the steward and the shifting nature of nature itself may kind of help counteract that, because the use of the land, a use of natural resources and protecting of the biocultural rights are going to kind of naturally they kind of must shift. And I wonder if the real benefit is that they create something that just kind of has to be checked in with as society and economies kind of change. And it's just one of those things that it kind of, it makes you, you being kind of like, in the collective sense, stop and think like, okay, this is something we want to do in this one area, but wait, we need to understand what the potential effects may be. And as that consciousness kind of grows, it could be that those, as economies and livelihoods and cultures shift, biocultural rights and awareness of them just kind of become more and more integrated naturally over time. That could be very rose-tinted glasses of me, but the potential is there, I think.
Yeah, no, absolutely. Absolutely. Thank you so much for sharing your thoughts. I would actually say that, you know, we shouldn't think of people, of communities that have this special bond between, you know, even their new or their old or their traditional practices with the environment. We shouldn't see them really as stewardships. Like I don't agree with that vision. More than stewardships, you know, they're interested in not seeing their livelihoods disturbed and basically surviving. that's I think their most, you know, their utmost concern. So yeah, I think this would be a far more easy way of you know, try to get, you know, the attention of institutions and states and governments on environmental protection, because it has to do mainly, and you know, like some people will, you know, crucify me over what I'm about to say, but at the end, you know, biocultural rights are very anthropocentric and they're very, you know, human oriented, and but they actually, in my view, hit the spot in regard to what we have to protect is our, you know, relationship with the environment, even if that sounds horrible and if it sounds like we don't respect you know, other species, you know, own interests, if we don't care about multi-species justice and all these new inclusive and wonderful, you know, ways of seeing the world. But you know, we can all agree that, you know, the shift in understanding of natural relationships is happening at a very slow pace, and you know, environmental degradation is happening, you know, 10 times faster, if not more. So I think it would be a good way to start framing the question and then trying to make other links. Because, you know, when it comes to rights-based approaches, I believe, you know, I mean, not one by itself is a panacea. But then again, if we can have everything all at once, then that might, you know, have a positive impact. If we can have rights of nature, if we can have a greening of environment, of constitutional rights, if we can have environmental collective rights, if we can have procedural environmental rights, if we can have, you know, the right to a healthy environment, if we can have other things like the in dubio pro natura or in dubio pro aqua, and all of these, you know, developments that we've been seeing in the late years, so we can actually, you know, achieve curbing, you know, environmental degradation, you know, from a legal perspective.
I definitely agree, Julian. Just to clarify, I definitely take your meaning about not liking that term stewardship, and how the need for protection is much more immediate in terms of livelihoods. I think what I was very clumsily meaning when using that term steward is just humans in general, in a very real sense that, as you say, these are very anthropocentric constructs. It's ultimately to protect us. And that's kind of what I was getting at, because if we as a species, as a group, do not try and take care of these systems while supporting our livelihoods, etc., nature is probably going to be fine without us, as grim as that is. So yes, thank you for your points.
No, thank you as well. I subscribe completely to that last assertion.
Ooh, on that note, are we good to move on to part 3? Because I'm just conscious of time and I don't want to keep people any longer on a Friday afternoon.
Conference goes on forever.
Cool. So basically part 3 of this lecture is going to touch on some of the questions we were getting there, but basically just bringing part 1 and 2 together to reflect on and discuss how biocultural rights could act as this useful instrument for communities, and in this context, Irish communities, to resume their role as stewards for their local environment that could kind of recognize that local cultural and natural heritage to further environmental protection. And obviously we're kind of largely discussing trees and obviously Ireland in this case. These reflections could undoubtedly be considered in different kind of habitats in the context of different ecological features, and of course geographical locations as well. To give you some context about the current ecological situation in Ireland, obviously similar to countless countries across the world, we are suffering from severe biodiversity loss nationwide. On the topic of trees, our forestry coverage only accounts for about 11% of our total land area, with the EU average being around almost 40%. In a 2019 Status of EU Protected Habitats and Species report, we can see that 85% of Ireland's habitats were deemed to be unfavourable, and almost 50% of habitats were indicating trends of decline. And while afforestation efforts are underway, non-native monoculture plantations are said to dominate these tree planting schemes. And to bring these kind of discussions to life as such, we've chosen a woodland in County Cork, which is the south of Ireland, you can see on the red dot there, to act as an example of how potentially communities could make this connection between their kind of local heritage and biocultural rights. So in a 2010 study by Perrin and Daly, they surveyed Ireland's ancient woodlands, and they designated Glengariff Woods as one of these ancient woodlands. You can find references to this woods in kind of maps dated in 1592 and historical surveys dated as far back as 1603. Now, it was exploited for timber in the past, so these woodlands are much less extensive than they are today, but they are now a designated nature reserve, and they're about 300 hectares in coverage. And the woodland is part of an SAC, a special area of protection, a special area of conservation. under the Habitats Directive. And under the SAC, along with Glengariff Harbour, it's home to a number of protected species and habitats. So that includes the Kerry slug, the lesser horseshoe bat, the otter, the common seal, the alluvial forests, and notably these old sessile oak woods. Now, these oak woods, they make up a significant portion of the woodland, almost half. And according to the National Parks and Wildlife Service, this woodland, it's one of the best examples of oceanic sessile oak woodlands in Ireland. And for some kind of national overall context, the oak tree accounts for about 2.5% of Ireland's total forestry coverage. Now, all trees have value, of course, but these surviving ancient woodlands are of particular importance because of the biodiversity that they support, their cultural significance, and also the fact that many of these ancient woodlands embody these potential links with prehistoric wildwoods. In terms of cultural heritage, Perrin and Daly also write that ancient woodlands are often the source of archaeological evidence, including features like charcoal hearths, wood banks, or pollards, that basically just gives us this insight into how the land was used in the past and traditional forms of land management. Now, remembering that significant role that the oak tree played in ancient Irish mythology and law, as we discussed earlier, there could be an opportunity here to demonstrate that Glengariff woodlands is an important part of local natural, cultural, and legal heritage, and kind of use that heritage and that history to connect with the local individual's sense of place and community to instigate greater and potentially more proactive environmental stewardship. Regarding the SAC status of the woodland, unfortunately, Ireland doesn't have the best track record when it comes to the enforcement of environmental law and regulation. In fact, you can see a 2021 report from the National Biodiversity Forum. So basically, they're auditing the interim review of Ireland's National Biodiversity Action Plan. And they state that, quote, the biggest transgressor of environmental law in Ireland is the state. And you can see evidence of this even in a recent case that was brought against Ireland by the Court of Justice of the EU, where they found significant inadequacies in the implementation of the Habitats Directive, including the failure to designate over 200 of the 423 SAC sites in Ireland, and the failure to define the conservation objectives of 140 of these sites. It was quite damning, that the findings of this case, because they said, quote, a persistent and systemic practice of establishing conservation measures that are not sufficiently precise and that fail to address all significant pressures and threats. And they found ultimately that Ireland had failed to fulfill Article 4.4 and 6.1 of the directive. And while these transgressions are significant, absolutely, in terms of the kind of conservation and restoration efforts, the regulations in relation to Glengariff Harbour and woodlands, as we can see here, they have been enacted into Irish legislation in accordance with the Habitats Directive, which means that they have established conservation objectives. They established them in 2015, although I wasn't able to find any updated objectives since then. And that also means that consent from the Minister for Agriculture, Heritage and the Gaeltacht must be obtained if activities such as tree felling or the burning of clear vegetation is to take place. And while illegally carrying out such activities like those, it's punishable by fines or imprisonment upon summary conviction, there are, again, past and ongoing issues related to the reporting and prosecution of environmental offenders in Ireland, which means that in reality, many of those who commit such acts actually remain undetected, unreported, and unpunished. And in the case of biocultural rights, like we're talking about today, could they offer an opportunity to reassess existing environmental obligations in a manner that kind of reaffirms this interrelated and reciprocal relationship between people and their environment, and that our use of natural resources is very much dependent and related to our responsibility to ensure that we stay within ecological limits and respect planetary boundaries. Then again, aligning with and reinforcing said environmental objectives, like those found in the Habitats Directive. And on that note, I'm going to pass you back to Julian, who's going to keep going with part 3.
Thank you so much, Neve. For this last bit of our presentation, part 3, we wanted to discuss exploring the possibility of setting up a biocultural community stewardship of Glengariff Woods. So as we saw with the Florence Declaration, recognition of biocultural diversity and biocultural rights can also be extended to less diverse places in modern societies, such as European societies. So besides natural areas of ecological importance to a local community, other green areas in cities or in industrially developed areas, rural areas, can be considered as biocultural multifunctional landscapes where the special relationship of local communities with nature is worthy of protection. These areas can be remnants of pristine ecosystems, patches of ancient agrarian landscapes, designed urban green spaces even, new urban ecosystems that arise by chance or as a side effect to other developments, such as derelict industrial sites. Local urban and rural communities surrounding Glengariff ancient woodlands could vindicate Brehon law as grounds of a special relationship with all Irish trees for their economic and cultural significance, as we just saw. This relationship with Glengariff woods, viewed under a holistic approach, could be repurposed for new and rural urban contexts and focus the stewardship on caring for the larger network of relationships defining this social ecological system. So, as Niamh mentioned, the ancient classification of trees regarding their utilitarian value for their fruit, nuts, bark, wood, and resin fits with the current notions of supporting or providing ecosystem services, or as they're known now as material nature's contributions to people. Moreover, the fact that causing harm to trees warranted penalties based on the principle of restitution is evidence of the economic, but also of the cultural importance of such elements of nature. In the particular case of oak, yew, and ash trees, they had both a material and spiritual significance as purveyors of sustenance for the community, but also as beings of mystery with its folklore, which explains, the higher protection offered to them. And you can already see, they're supplying ecological and aesthetic value. So considering that, Asian woodlands are mainly composed of oak, ash, elm, hazel, yew, and other native trees and shrubs, and you can see the extremely delicate situations of these ecosystems in Ireland, and in particular in that region, due to exploitative forestry activities, the link between the two is evident. So, next slide, please. So to set up a biocultural stewardship of the Glengariff Asian woodlands protected by biocultural rights, West Cork communities must engage in a collaborative and collective construction of new knowledge. This process, although challenging, is intended to integrate the different knowledge systems of all diverse members of West Cork communities by axing them in three superposing elements. For the first element would be the self-definition of the local community. The second one would be identification of shared local values of this community that support a holistic way of promoting nature conservation and sustainable use. And the final element would be, political engagement of the local community in respect of its own protocols and its biocultural rights. So it's a processes that can be somewhat difficult in the way that all regions nowadays in Ireland are culturally heterogeneous, given the pluralist composition of contemporary Irish state society. But however, there has been evidence that different knowledge systems that you can integrate, both autochthonous and exogenous, for example, indigenous peoples' knowledge, traditional Irish knowledge, ecocentric pluralist, global South, feminist, and decolonized approaches to the environment can be integrated in such contexts to advance biocultural stewardship objectives, and be put together in this communal effort and collective effort, due to the fact that they share these three elements that I just mentioned. The final aim would be to set up a practice of conserving, managing, monitoring, transforming, educating about, and advocating for a wide range of quality life issues regarding the ancient woodlands and its neighboring local communities. Next slide, please. So on a final note, we wanted to propose a sort of roadmap of what a possible biocultural community stewardship of Glengarry Woods would look like. This roadmap is based on documented experiences of other Indigenous peoples, ethnic and local communities, and it's composed of 3 actions that we consider could, be taken into account by West Cork communities if they wanted to do so. The first one would be aligning personal ethics, collective environmental values and concerns for community well-being with existing institutional environmental goals and scientific knowledge of the environment and Glengarry Woods. Evidence shows that local communities have experienced success in producing environmental improvement, community building, and personal satisfactions for those involved when personal and organizational dimensions and objectives in these kinds of projects are integrated. The second one would be establishing a community protocol to set out rights and responsibilities regarding legal protection of livelihoods or ways of life, depending on the environment, trying to assure broad public participation and including potential restoration efforts of Glengarry Woods. So crucial to these protocol is ensuring that it includes a full spectrum of perspectives, especially those of women, youth, the elderly, and others who are often excluded from decision-making processes. To this vast array of stakeholders, LGBTQI+, traveler, Roma, and immigrant communities must be added. So the broader the participation and representation, the greater the consensus, the collective learning, and participants feeling personally invested in a particular biocultural stewardship process. Coming back to how public participation in Ireland works, we mentioned that West Cork communities could use the Public Participation Network platform to integrate biocultural community stewardship of the old trees in Glengarry to a network of other social and ecological organizations in the county. Through this public participation network, they can access relevant information and funding and grants, and they can also access training and education to support the initiative's work. They can also explore citizen-led approaches to public consultation outside regular public consultation engaged in by the Irish government, and try to assess the social, environmental, and cultural value of Glengarry within the local community, and the need for more non-state actor participation in monitoring and enforcing existing environmental regulation regarding ancient woodlands. A second thing that we think is most important is that biocultural rights could be used here to prompt and inform appropriate environmental management and potential restoration efforts of Glengarry Woods. Some ecological challenges that communities would engage with may include issues of overgrazing by domestic and wild animals, which is inhibiting natural regeneration of ecosystems. It could also consider the presence of invasive species such as rhododendron, which is a widespread issue in Ireland, and alongside ineffective management of plants of such a species. Or it could also address concerns around how adjacent and nearby agricultural practices may be negatively impacting species or water quality, for instance. Last but not least, we also propose that West Cork communities could use biocultural stewardships to engage in political action and raise public awareness about degradation of Glengarry Woods and the need for local and national authorities to proactively engage in action to avoid its destruction. So this would be the end of part 3. I will leave it back to Niamh for some brief concluding remarks before closure.
Thanks, Julian. Just to kind of wrap things up before we kind of open back maybe for a few minutes of questions and discussions. Mancon Magan writes that Irish people tend to regard both our history and our geography through this mythological lens, realizing that myth could hold certain inalienable truths. Now, obviously, we can't just interpret all myth as fact. He writes that anthropologists have found there to be some truths in the inherited knowledge of Ireland's mythology, and he compares it to the way Indigenous stories are found to contain ancient knowledge. And while we saw that obviously trees weren't bestowed explicit rights under Brehon law or anything like that, they were protected and highly regarded in both law and society. And this is a quote from an 8th century legal poem translated by Binchi, which I think kind of summarizes this kind of topic and those values quite well. A danger from which there is no escape is the penalty for felling the sacred tree. And setting up those biocultural stewardships for rural ecosystems, for heritage sites or urban settings like we've been talking about today, it could allow for conservation approaches to be carried out in a collaborative partnership with community members, approaches that could be tailored to and respect the experiences and needs of local communities, also in a manner that recognizes those interrelated social, cultural, kind of recreational and environmental and practical value of local environments. In this context, biocultural rights could act as this useful political governance or community engagement tool that could allow us to revive that kind of essential connection with our local environment, both culturally and legally, to the benefit of our people, and of course then to our declining ecosystems as well. So thank you very much for your attention. You have our contact details there on the screen, and if you have any, I know there's some things in the chat as well, but if you have any thoughts that you want to share, please do feel free.
There's a hand from Anjali.
Hi, thank you so much for your presentation. My name is Anjali. I'm in Alaska. I'm Alaskan, but I'm actually a PhD researcher at Ulster University in Derry, speaking of ancient trees, Derry meaning oak. And I am thinking about the grassroots sort of vision for biocultural rights and biocultural heritage and how that correlates to the way that we actually go about conservation these days. I'm thinking in Northern Ireland, like the Woodland Trust, for example. And are non-governmental or governmental organizations, does that count as local community grassroots organizing? I'm just trying to square modern systems of governance and organization with the kind of stipulated requirements for biocultural heritage and biocultural management.
Yeah, that was one of the things that we were precisely trying to convey here, that since the notion of biocultural rights should be expansive and interpreted not in a narrow sense, but in a sense that everyone can enjoy biocultural rights, you don't have to be this certain group with a long-standing tradition of a livelihood dependent on the ecosystem. You can also be someone in your town that is worried about the local patch of trees the local patch of trees going to be felled, or someone that cares about a new ecosystem that popped up because they abandoned that quarry, and now there are animals and other species coming back to it. So I think the notion of that, I mean, the importance of it is that it is a tool for you to establish this kind of like relationship as a group. It has to be, of course, a thing of collective rights, which is also a bit challenging because most legal systems are made of vindication of individual rights, but it's this collective right to support your livelihoods on this, but not also that, but other things that you get out of nature, other kinds of values or contributions of nature to your own well-being that you get from it. It's aesthetic value, its recreational value, its cultural significance for you. It doesn't have to be, something, traditional or spiritual or religious or mystical. Some people have it, some communities have it, and that's okay. But you can also use this platform to do that, in our opinion, because that is what it's for. It's supposed to be a human right that is linking one of the most defining aspects of humankind, which is culture, and the need for culture to have an environment to thrive in. So that would be, let's say, our take on it. Yes, Rembrandt.
You're muted, Rembrandt.
Sorry, then you just saw my attempt to get my thinking right. Well, I'm trying to grasp this, and especially with your last comment, Julian. So apologies for not being a lawyer, but it seems that what you're doing here is building ammunition, building frames, building protocols that somehow have their roots in substantive law and rights that you can relate to already existing rights, where at the very same time you propose almost like a program for people to pick it up or to innovate or to build their own practice. Possibly not with all of the law supporting, but at least because it has its foundations in old systems or existing principles or existing rights, it gives substance, it gives power, it gives an option for standing your ground. That's the kind of word. Is this kind of sort of the correct way of understanding?
I would definitely say it is. It is, and it's not a proposal of me or us, as the honor we have today of being your lecturers. It's something that has been tried by other communities worldwide. It comes, for example, from the Black ethnic communities in Colombia that have organized themselves in such ways and have availed of a country that has been, for example, very eager to recognize rights, but very, very sluggish and very lazy in upholding them and implementing them in reality. And we're also telling people that these experiences have been documented and that people have tried different paths and different ways to get around, and that there's a few things that you can take into the consideration if you want to organize yourself. If you were interested in assuming, let's say the defense of an element of nature, or a particular ecosystem that is dear to you and your community, and that this example can be replicated everywhere. And this is not something we invented. It's in a principle of declaration made by Florence, by people that were jointly working with, I think it's an architectural organization and the CBD, that said, like Europe, even though, there's hardly ethnic and, indigenous peoples communities or whatever, there's a transformation of the landscape that also, can afford biocultural rights protection for people in different settings, in urban areas, in rural areas. So yeah, your depiction of the thing would be 100% correct. And then, what are we doing here would be, we would like to ignite the discussion, spark new ideas, be a spark to new ideas and to new movements, and, tell people that it is possible to avail of this, and that they're just not right sitting on some, text and, being discussed in other things, that they also can have, practical application.
Yeah, I have a case, but that goes beyond what we're doing right now. So is it okay to contact you again? And
yeah, sure, go for it.
Thanks very much. Brilliant.
My pleasure.
And can I just jump in there before, I know someone has their hand up there, but the three, say, actions that we kind of propose through this lecture, like Julian was saying, it's just kind of that jumping off point. It's like a starting off point, and it's not necessarily kind of the only way that these kind of biocultural rights or these connections could be made in communities, and it's not necessarily kind of the best way, but just kind of to ignite those conversations like we were talking about. Because I was discussing Brehon law and kind of those ancient trees and the mythological connections and the Irish language connection a couple of weeks ago at a community event in Cork, and people really just were able to connect with that idea of kind of taking back their cultural heritage and connecting with their history and using that into how they approach environmental management and environmental protection. And I definitely think this isn't kind of legal at all, but that there's something very powerful there, that people they can connect with this idea, and it kind of ignites something in them. I think that's really valuable and powerful, kind of on a grassroots level. And I think that's what, in these kind of discussions, definitely holds a lot of potential to work with in the future, and kind of use that to drive, more proactive engagement and things like that.
But in making the connection to all principles and law, you have a super empowerment tool. You have a super tool for legitimation of those kind of bringing those kind of values in practice. Whereas if you do not have that connections, or if you cannot sketch those connections, well, I'm not saying people will not do it, but it gives something extra.
Yeah, absolutely. I think there's two hands up there. Is it Ruben? Do you want to come in there?
Yes, thank you so much. I'm a political ecologist from Robert Gordon University in Scotland, and I just first of all want to thank Niamh and Julian very much for the presentations. Lots of interesting food for thought here. I just wanted to kind of expand on something that has already been covered in some of the questions in the earlier break around kind of problematizing the concept of environmental stewardship underlying this notion of biocultural rights. And I wonder to what extent, or even, within the scholarship that you engage with, that is further problematized, because I feel like it's romanticized in the way that it is this underlying essentialized, unitary, socio-cultural vision of what local or indigenous communities are supposed to be, right? Their major or main priority is supposed to be nature conservation. I know that Julian mentioned, their primary objective might be survival in the first place, and that's certainly the case with a lot of the communities that I work with in Southern Africa and Namibia. And if anything, their priorities might be in conflict with nature conservation objectives, right? So the kind of problem that I have with this idea is that, again, it feels like it's supposed to be a decolonizing tool, yet depending on the context, of course, we talk about, this might not be the case in Ireland, but in other contexts potentially, it's again something that is imposed from the top and kind of a global conservation priority rather than a local community priority. Again, very context dependent. But yeah, any further thoughts on that would be greatly appreciated. Thanks.
Wow, Ruben, thank you so much for that. That was really interesting. I was actually gonna, I was actually thinking a few things about that. Like there's also the supposition and the scholars that have talked about biocultural rights say so about the noble myth, the noble savage myth, as you mentioned it. It's very naive to think that indigenous people's communities local communities are going to act in this stewardship kind of way, because what they intend to do with their traditional practices is to engage in environmental conservation. these dangers have been all set out. That's why we, like, it's impossible not to use the language of stewardship and that. And I totally agree with, I totally subscribe what you say. It's not possible to, you know, not link yourself with that kind of vocabulary once you get into the whole reading of the literature and all of that. But I would say I would like to probably, you know, direct you to the considerations, the arguments of the Colombian Constitutional Court regarding biocultural rights. This is the notion that we thought would best fit this kind of you know, rights in between, you know, environmental protection and cultural diversity, because this notion, you know, rejects the idea of stewardship in that way that you would be supposed to you know, implement always this sustainably friendly way of life in order to enjoy these rights. What we were trying to advance is that they actually are worthy of protection in themselves. You don't have to you know, prove at every time that you're, you know, living in your land or doing your traditional ways of life or livelihoods in accordance to sustainability. Because yeah, we can discuss you know, the concept of sustainable development, and we can discuss you know, if that is, you know, compatible with conservation or with you know, economic development in itself, and if it's not a contradiction, if they're not competing narratives. I would definitely, you know, agree with what you say, and would actually think that there needs to be definitely a reformulation of biocultural rights in scholarship, in literature, that, you know, dismisses this idea of stewardship, because that is not what they're doing. You know, that is precisely what it happens, is that this relationship between nature and culture is, you know, pivotal to human dignity, and that is what is protected, not the fact that, you know, you're engaging in conservationist, so to speak, practices, which would be, you know, very paternalistic and and inappropriate to think. And thank you so much for your contribution. Really, I thought it was very interesting. Thank you for your intervention.
I wonder, I'm just conscious that we're technically out of time, and maybe our speakers are feeling a little exhausted. I wonder, we've got 2 hands up and a question in the chat. I wonder if we could just take, oh, Kathleen's put her hand on, maybe gonna put it in the chat. I wonder if we could take Eleanor's question and then a quick answer, and then maybe I would encourage you all to keep this conversation going. There is an incredible Padlet that our speakers have given us with the slides and other resources, and they provided their contact details on the last slide, which I'm going to interpret as an invitation for everyone to send questions and keep engaging with them. So maybe we can just take Eleanor's question and have that be the last question of the panel. Thank you.
Thanks. I'll keep it short. The end of the previous answer was actually a perfect segue, because I was wondering, how do you go about dealing with potential conflicts or tensions in what communities see as their biocultural rights? And then I'm thinking, for instance, of the case of whaling in Norwegian communities, and this tension with the broader community who thinks that this cannot be justified anymore. I know it's an extremely difficult topic and you can't give me a clear answer, but I was curious to hear your thoughts.
Yeah, like in that case, I would say it would come down to, you know, a more legal thing of balancing of rights. And, you know, in a specific case, there would be no definite answer to that one. And then you could say that, you know, both communities could have, you know, biocultural rights even that can be competing and that can be conflicting. And that is a risk that we signaled on the presentation, that biocultural rights, as any other types of rights, can go into conflict not only with themselves, but with other kinds of, considerations. Probably in this case, if you ask me if I was, doing constitutional judicial review, I would say that probably indigenous people's rights would win. But then again, it would have to be thought of in a concrete scenario to be able to, to see who can trump who. The other question that we have is from Aoife Daly, to whom we say hello. She wonders how would this approach would work with other international human rights standards. I would say this approach would be complementary. I don't think rights-based approaches to environmental protection should be, excluding each other. I think they all should be working, and trying to be interdependent and trying to fill the gaps that one protection leaves behind. So it would be like some sort of, system in which a deficit of protection would be, or a lacuna would be filled with another right that can ensure that protection. The only thing is, how do people do it? How do people manage to do that? It would depend as well on what would be, the stakeholders of a particular situation for that to be determined.
Did you want to add something, Niamh, before I say goodbye to everyone?
No, I think Juliana's kind of summarized it all quite well. I explored kind of Brehon law and those considerations also in the context of rights of nature as well, which kind of leans into what he was just saying there, that all these kind of rights, especially say in the international context, they don't have to kind of, it's not just kind of one or the other, but they can all kind of, I suppose, work together towards that goal of ecological protection and human protection as well.
Thank you. If I could just make you bear with us for 2 more minutes of excessive, effusive thank yous. This is the last panel of the 3rd annual School for Human Rights and the Environment, hosted by the Global Network for Human Rights and the Environment and United Nations Environment Programme, and it's been an extraordinary panel to end on, and a panel that's kind of left me wanting more. Maybe I'm singular in that respect, but it's been just such an interesting discussion. The discussion has happened in the chat, the discussion has happened in the room. We couldn't stop talking to you. We didn't let you have your 5-minute break, and I think that's just an indication of how excited and fascinated we were by this, how fascinating it was to be thinking about Brehon law and biocultural rights and bringing those things together. It's just been a wonderful talk. So thank you very much to our speakers. Thank you for your Padlet, which is wonderful. I encourage everyone to go and have a look. Thank you to our audience, many of whom I now feel like I'm getting to know from multiple panels. Thank you for being here with us throughout the week. Thank you to Zara for helping us make the summer school happen. She's our summer intern at the GNHRE and has been doing just tons of background work as well as foreground work. It was a totally wonderful panel, and I'm very glad that Alana is in the room, because Alana got up at 2 o'clock in the morning to present at our very first panel of the summer school, and you guys are all here at 7 o'clock in the evening on a Friday, or whatever time zone you're in. So just the kind of time and energy, dedication is fully represented in this room, and I just want to acknowledge that and to thank you all. On behalf of the GNHRE and UNEP, have a wonderful weekend. All of these sessions have been recorded. They're available on our YouTube channel, so please go and check them out and watch them again. And see you all at the 4th annual online Summer Winter School hosted by GNHRE and UNEP. Bye, everyone.
Bye. Have a great weekend. Thank you.
Thank you.
Bye everyone, till next year.